All right, welcome everyone to Understanding the Basics of Federal and State Seed Laws. My name is Audrey Thompson, and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. Today's webinar is part of the Center's Understanding Agricultural Law series, a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not necessarily specialize in agricultural law. Next. This series is wholly sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, established through the 2019 Pennsylvania Farm Bill. The Agricultural Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through low-interest loans and grants. Next. As you can see, we have covered numerous topics so far, including ag labor, land use regulation, crop insurance, conservation programs, ag finance, Pennsylvania's Clean and Green program, and many, many others. Materials and recordings for these webinars are available on our landing page, which I am putting in the chat right now. If you're interested, you want to click on that, as well as our website at aglaw.psu.edu. Next. Upcoming topics in our Understanding the Basics of Ag Law series include the Fair Labor Standards Act, the Perishable Agricultural Commodities Act, and food labeling. Those are all on Fridays. They're all at noon, and registration is up and available for them, for all of them, on our events website page. All right, I will now turn this webinar over to Jackie Schweichler. Jackie Schweichler is a staff attorney at Penn State's Law Center for Agricultural and Shale Law, where she researches numerous agricultural law issues, oversees student research assistant, serves as the primary author for the Shale Law Weekly Review, and manages Pennsylvania's Agricultural Mediation Program. Jackie, the screen is all yours.
Awesome. Thank you, Audrey. Appreciate it. All right. So these are the main laws that we're going to be looking at today. This is meant to be a pretty broad overview, so we're going to touch on these kind of quickly. And if you have questions, please put them in the Q&A, put them in the chat. And if you really like one of these laws and you want to do a deep dive, let us know, and maybe we'll do a deep dive webinar on it someday in the future. So first, we're going to be talking about U.S. patent law, then the Federal Seed Act, then the Plant Variety Protection Act, which I'm going to refer to as PVPA a lot. And then we'll talk about state law, and we'll talk about Pennsylvania's Seed Act. Oh, this is just the same slide as the previous one. I included the hyperlinks on this one, though. So in case anyone already downloaded the PowerPoint and you're going along with it, you can click on these links and see these acts for yourself. And all these links are also included on our resources sheet. But again, they're here as well if you are interested. So very, very generally, for anyone who may be new to this topic, and I know we've got some students attending today, I wanted to ask the question, what do seed laws do? So seed laws do a couple of things. So one of the things they do is they provide legal protection to businesses or companies who create or develop new seeds. These are intellectual property protections. So when we talk about this now, we're generally referring to seeds that have been developed by a large corporation, but this could also apply to small family-owned businesses, right? For example, like let's say that there's a farm where they've been carefully selecting the best tomato seeds for generations. It took a couple hundred years, but now they have the absolute best tomatoes. That business probably has an interest in protecting those seeds so that others aren't reaping the benefits of their work. The official stance by USDA is that we have these laws to encourage the development of new plant varieties, which are very necessary to feed a growing population. The second focus of seed laws is to require testing. Generally, seeds have to be tested in order to avoid the spread of invasive species and to protect the environment. I feel like this is pretty self-explanatory, so we don't need to go into the dangers of invasive species or the problems with weed seeds. But you'll see this when we're talking about Pennsylvania Seed Act. Who do the laws apply to? Pretty much anyone. Farmers, landowners, seed companies, anyone who's selling or buying seeds, essentially. I threw in this slide as a little more background to show who we're talking about whenever I mention seed companies. This chart was published at the beginning of this month, so this is October 2023 for anyone who's watching this on YouTube. And as you can see, the range is from 2018 to 2020, and it shows the 4 firms which have the largest shares of seed and agricultural chemical sales: Bayer, Corteva, ChemChina's Syngenta Group, and BASF. This chart right here just focuses on like corn, soybeans, and cotton, but at a quick glance, you can see how much of the market Bayer and Corteva have covered in particular. Bayer's that brown color, Corteva's that yellowish color, and you can see that between Bayer and Corteva, they cover most of the market for those products. Which is why actually you'll hear me use them as an example a lot during this presentation. So that's why I do that. All right, so first up, I skipped a slide there, sorry about that. So first up, I wanted to start with a timeline to show you what we're going to go through here. So we'll start with the 1930, the Plant Patent Act, and then we'll go to 1939, where the Federal Seed Act was put in place, and then 1970, where the Plant Variety Protection Act. Okay, so going through these sort of in chronological order, we're starting with the Plant Patent Act. This allowed companies to acquire patents for asexually reproducing plants. Now, when I say asexually reproducing plants, we're talking about plants that are the genetically identical offspring of a parent plant. They're reproduced by budding, grafting, cutting. Some examples of this would be strawberries or dandelions, blackberries, ferns, things like that. On the other side, sexually reproduced plants are going to be those that are reproduced by seed. And just a note here, this act does not apply to tubers, just potatoes, tubers, potatoes. This act really opened the door for intellectual property for seeds. So this was kind of the opening the door, letting this IP be protected for new genetic varieties of seeds. And we can't talk about plant patents and seeds without talking about GMOs. So Diamond v. Chakrabarty was this landmark case for the seed industry. If you know anything about seed law, you've heard about this case. So Ananda Chakrabarty was an employee of General Electric and created a genetically modified bacterium that could break down crude oil. The purpose was, of course, to treat oil spills, which is, remarkable. So GE filed a patent application listing Chakrabarty as the inventor, but the application was rejected because at the time, living things were generally not considered to be patentable subject material. The case ended up going to the Supreme Court, who decided that microorganisms can be the subject of a patent. And again, that changed a lot as far as GMOs are considered. So diving into the type of patents that we have. The first type of patent is simply called a plant patent. Plant patents apply only to asexually propagated plants, so they don't apply to things like edible tubers, potatoes. The purpose of this asexual reproduction is to create uniformity and stability. It creates an offspring plant that's a clone of a single parent plant. With this method, you can create millions of plants that are exactly identical. So, if you've got a rose bush at your house that's resistant to drought, you can asexually reproduce that rose bush to create a garden of drought-resistant roses, which is nice. Now, if you have a plant patent, it means that others may not asexually reproduce your plant, sell your plant, or offer parts of your plant for sale. The United States plant patent will expire after 20 years, and after that, the plant belongs to the public. That. On this slide, I've added some of the exact language for plant patents. So to acquire a plant patent, you need to show that the plant was propagated asexually and has distinct characteristics from other plants. Pretty straightforward. Now, the second type of patent is a utility patent. These can be obtained for a variety of different inventions, processes, machines, or materials. You've probably heard about them before in the context of, any kind of invention, really. One of the main differences between the utility patents and the plant patents is that utility patents apply to both asexually and sexually reproducing plants. It's also generally considered a more difficult to acquire patent. So it's a little harder to get a utility patent, generally. So what they do is they preclude farmers or growers from planting or selling the seeds. In other words, no seed saving. So, that's the same for anything. If you buy seeds that are protected under a utility patent, you're not allowed to collect those seeds and plant them on your farm or sell them to anyone. If you like those seeds and you want to keep using them, you have to buy them every year from the producer. And utility patents also last for about 20 years. Well, exactly 20 years. I wanted to throw in an example here to really make the point, because I think this is a pretty well-known example. So Monsanto, which is now Bayer, of course, we know that, but Monsanto's Roundup Ready soybeans. These are a type of herbicide-resistant GMO, or technically genetically engineered plant. So if you buy Roundup Ready soybeans, you can't harvest the seeds at the end of the year to replant the next year. And you definitely can't sell those seeds. If you've never bought their seeds, you might not know this, but anyone who buys Monsanto's patented seeds, they need to have a signed and valid Monsanto stewardship agreement. This agreement is a contract that says that you agree to abide by Monsanto's rules. And basically, you're agreeing to not save or sell the seeds. So they have it in writing. They have this contract with anyone who is buying their seeds. So Monsanto, and this was on their old website, Monsanto's stated policy on their website before they were purchased by Bayer is that they won't sue farmers when their patented seeds or seed traits come to be in a farmer's field by accident. An accident referring to seeds that are blown by the wind or carried over there by an animal or bird or something. However, this seems to be a great concern for a lot of farmers who worry that if enough of their field becomes saturated with Monsanto seeds, Monsanto will come after them. The concept is pretty demonstrated in this case, Monsanto Canada v. Schweichler. But in this case, it's a little bit more than trace amounts of Monsanto seed. The field in question was found to be 95 to 98% Roundup Ready canola. What happened was that Monsanto's canola seeds initially blew over into Schweichler's fields, probably from the wind. And then Schweichler noticed these seeds, and he was using Roundup on the weeds at the edge of his property, and he noticed that some of the canola plants that had gotten sprayed managed to survive. So he knew that the plants were probably from the neighboring fields who were using the Monsanto canola seeds. So he sprayed the entire field with Roundup, which killed everything in the field except for the Monsanto canola seed with the Roundup-resistant traits. And then Schweichler collected the seeds from that field and then replanted his property with those seeds the next year. And that's why the next year his field was pretty much purely made of Monsanto canola. He then purchased Roundup and was able to spray his fields without damage to the majority of his new canola crop. This is really clear-cut. There really was no argument that he could make for inadvertence. While the initial seeds that came over into his property, yeah, that was inadvertent, they're blown over by the wind, but his actions in saving those seeds, and killing his other crop, that was incredibly purposeful, and done so that he could benefit from the use of Roundup. And so in this case, the court ruled in favor of Monsanto. This slide is unfortunately a little outdated, and I wasn't able to find an update because this website no longer exists, because again, Monsanto's site's a little different now that they're owned by Bayer. But in any case, from 1997 to about 2019, Monsanto claimed that they filed 147 lawsuits for patent infringement. Of those lawsuits, only 9 of those cases actually went to a full trial, and Monsanto won all of them. Take from that what you will, but to me, it shows the power of these seed patents. And then that people aren't going to get away with, the inadvertent, the wind blew it over, and then I'm taking advantage of that. And I have another case on patents. So in 2011, the Organic Seed Growers and Trade Association, and then a bunch of other groups, filed this lawsuit against Monsanto in a preemptive attempt to protect themselves from being accused of patent infringement. So they're trying to sue Monsanto to stop Monsanto from suing them for patent infringement for inadvertent use of their seeds. If that's a little confusing, that's because it is, because they were trying to sue them to stop themselves from being sued. Now, to bring a lawsuit, you usually need to be able to show that an actual injury has occurred. Here, none of these groups were ever accused by Monsanto of patent infringement. So the court just ultimately dismissed the case. I wanted to include this slide because I wanted to show like there were and maybe are still a lot of fears about the power that Monsanto and these other seed companies wield with these patents that they have. So this was just a very interesting case to me. Like they were so afraid of being sued that they brought a lawsuit to sue someone else to stop themselves from being sued. I just think this really, really highlights the issue and the concerns that people have. Okay, moving on to the Federal Seed Act. This is another big one. This act covers any seeds that are sold across state lines or seeds sold to foreign countries. The purpose of the Federal Seed Act is to prevent the misrepresentation of seeds. Now, what do I mean by the misrepresentation of seeds? And this I'm talking about label requirements. So under the Federal Seed Act, the label has to say the specific seed variety or class of seed being sold. And seeds have to be certified by a seed certifying agency. Now, we aren't going to go into the process of seed certification, but if you're interested in this topic, a good place to start is the Association of Official Seed Certifying Agencies. This website will tell you where you need to go to find the right seed certification site. As for Pennsylvania, which we'll talk about a little bit more later, seed certification is handled by PDA, the Pennsylvania Department of Agriculture. And I have the links on the slide, and they are also in the resources document. Now, when it comes to the specifics of labeling, the Federal Seed Act requires companies to keep detailed records for transportation and delivery, and the requirements differ on whether the seeds are vegetable or agricultural seeds. Again, this applies to all seeds sold in interstate commerce, so anything sold between the states. So anyone who's involved in transporting seed has to maintain very specific records. They have to show where the seeds came from. They have to show how the seeds have been treated, like what chemicals have been applied to the seeds. And then the records also need to show the germination rate, how the seeds germinate or grow when exposed to appropriate growing conditions, things like that. Now, for agricultural seeds, the Federal Seed Act requires there to be a record relating to the purity of the seeds. So this has to do with the percentage of seeds that are actually like the main seed, the primary seed that you're trying to grow there, and then, not include the other random seeds that may have been mixed in by accident. So the Federal Seed Act is administered via cooperative agreement with each state. In other words, the federal government and states work together to comply with the act. The states have some requirements that I have listed here on the slide. They agree. The state's job is to sample seed lots traded within their jurisdictions. They're supposed to test seed lots for compliance with FSA, and then they submit samples where there's someone is suspected that the FSA has been violated. And they have to report that to the Seed Regulatory and Testing Division, the SRTD. Meanwhile, the Agricultural Marketing Service, they've got a few different responsibilities, so bear with me on the next couple of slides. They are going to, so their job is to authorize state officials for records and inspection, and they also issue notices and warnings to violators. They are also responsible for handling lawsuits and for training officials and scientists on testing, sampling, inspections, etc. And we don't need to get into the nitty-gritty of this. There's a lot of words on here, but you can look at these slides later. Okay, so how is the Federal Seed Act enforced? There's really nothing out of the ordinary here. Enforcement measures are provided under Title V. Violations of the Federal Seed Act are reported to USDA. The violator gets a warning letter in the mail, and eventually there could be civil or criminal penalties if things aren't corrected. This next form of Federal Seed Act is the Plant Variety Protection Act, or PVPA. This one's a little more complicated than the other patents, but this is a patent-like law here. The PVPA is administered by the United States Department of Agriculture. It allows breeders to acquire property rights for plants that reproduce by seed. So in 1994, though, an amendment extended this protection to potatoes, which is great. And then as of the 2018 Farm Bill, the PVPA also applies to asexually propagated plants. Again, this is similar to a patent. It provides seed companies with a 20-year certificate. It's generally considered a little easier for the company to acquire. And like a patent, violations include selling, purchasing, offering, delivering, or exchanging certified seeds when you shouldn't be doing that. So as before, if you purchase seeds that are protected by a PVPA certificate, you can't sell them. Usually. There is an exception, and we're going to talk about that in depth. I added this slide with the exact language of the PVPA because I thought the previous slide could be a little confusing because I kept talking about all the amendments. So again, the Plant Variety Protection Act applies to sexually reproduced, tuber propagated, or asexually reproduced plants, which is just about everything. Now, in order to acquire this license to protect your seed variety under the PVPA, you have to prove a few different things. You have to show that the variety is new, it can't have been sold for more than 1 year or sold outside the United States for more than 4 years. It has to be distinct. It must be clearly distinguishable from, common varieties. It has to be uniform. It can't be so varied that it's unpredictable and you don't know what's going to happen when you plant it. And it has to be stable. So the variety is going to be unchanged in the essential and distinctive characteristics in a way that is similar to varieties of the same category. So a quick summary so far of what we just talked about. The PVPA, it's issued by the Plant Variety Protection Office. It protects the sale, purchase, delivery, exchange of certified seeds, and there's a 20-year certificate. Now, the biggest difference between a PVPA certificate and a typical plant patent or utility patent is that farmers are granted an exemption when it comes to seed saving. So farmers are allowed to save seeds, PVPA certified seeds, if the sole purpose of saving the seeds is for replanting on the farmer's own acreage. Now, in addition, if the farmer saves some seeds for replanting, but something comes up, like the weather, they have money problems, there's a natural disaster, whatever occurs, but now the farmer doesn't need those seeds that they saved anymore, then the farmer is permitted to sell those seeds. You can probably see the potential problem here. How do you tell if the farmer's plans really changed or if they just say their plans changed so that they can sell the seeds? There's not a clear answer to that, but in this situation, like every other situation we see with attorneys and farmers, we're going to beg the farmer to please document everything. So let's say that my friend Jane, the farmer, buys PVPA protected seeds and she plants them. Then she saves the seeds for the purpose of replanting the next year. Now something happens. The field is flooded. Maybe Jane experiences some financial trouble, can't afford to do the planting, and that she planned to do. Now she needs to document this. Excuse me. She can write down what she had planned to do and why it didn't work out. If the reason is weather-based, she could print off something from the internet that shows, the rainfall, like what has been happening. Find some articles online that show that, there's been this natural disaster that destroyed her field. Take some pictures. Do whatever you can to have a little proof on hand, just in case AMS comes by and decides to check on things. Why did you save these seeds? If you get asked that question, you have a little bit of proof. So the exception that we're talking about here, again, I think it can be a little bit confusing. So the case I'd love to showcase and to give us a little bit of perspective is one from 1995, Asgrow Seed v. Winterbauer. Now, in this case, the farmer operated mostly through unlabeled seed sales or brown bag sales. So you know there's going to be an issue here. So 1 year, the farmer purchased seeds that were protected under the PVPA certificate for 265 acres of his land. He then sold about 10,000 acres worth of seeds from that crop to other farmers. Now, this case actually went to the Supreme Court, and they said that in this case, the seeds were sold for marketing purposes, and the marketing purposes were not exempted. The exemption was only meant to provide farmers with a way of saving the seeds for their own private purpose. So the farmer in this case had saved seeds from his. So if the farmer in this case had saved seeds for his own 265 acres for the next year, then he would have been compliant under the law. Or he could have saved those seeds for the 265 acres. And then if there's some reason where he was unable to plant these seeds himself, then and only then he could have sold those seeds. So he could have sold 265 acres worth of seeds and it wouldn't have, caused any problems. But 10,000 acres was a little bit of an issue in this case. So again, this exemption is incredibly confusing. We have an article about it that's that mentions this and describes it a little bit on our website, and that's listed in the resources document. So if I went over it too fast, you can read about it there. And on this slide, I have a list of some of the activities that constitute violations of the PVPA. First, under a typical PVPA, you can't sell a current standing crop for the buyer to take the plant and then save the seed. So you can't sell patented corn crop to a buyer when you know the buyer is going to save the seeds from that corn. Seems pretty clear. Next, you can't sell unmarked seeds, so no brown bag sales. Now, if you're going to sell seeds, they do need to be labeled. And you can't trade or gift these seeds that have the PVPA certificate. And then lastly, protected seeds can't be sold for use as a cover crop. Again, these are just some violations of seeds that have a PVPA certificate, things that you're not allowed to do. Since this lawsuit came out so recently, I thought I'd add a slide for it here. So in this case, Corteva has filed a complaint against Inari Agriculture, which is a Massachusetts-based company. Corteva says that Inari Agriculture used a third party to acquire Corteva's PVPA protected seeds, and then they made minor genetic modifications to those seeds. Now, Corteva is especially unhappy with the fact that Inari is now trying to obtain a patent for these modifications that they made. This is a new case. I don't really have any comments on it. It's something that we're just going to have to see how it plays out. And I actually found this case through the National Ag Law Center's email newsletter, which is the feed. So if you're interested in following cases like this, you can subscribe to the feed on the NALC website. Just thought I'd give them a plug. And they have a ton of great resources on seed law. And I think I have a few links to them on the resources sheet as well. Okay, so the last big law that we're going to cover, and certainly not least, we have the Pennsylvania Seed Act. So in 2004, the Seed Act and the Seed Certification Act were combined into Act 164. That was with Governor Rendell. Now, all seeds in Pennsylvania are regulated under the Pennsylvania Seed Act. So any seeds that are sold in the state have to be tested using rules from the Association of Official Seed Analysts, or AOSA. And the AOSA is an organization of state and federal and university laboratories in the United States and Canada. They have set standards on seed purity and testing processes. So this is the AOSA, is the group that creates the seed testing standards. The rules they create are made to comply with the Federal Seed Act. Again, they are state, federal, and university laboratories, just member organizations, and they do all this research and education, and they create the rules and standards. And I feel like I've said it now twice, but I feel like this is really confusing to some people. But the Pennsylvania Department of Agriculture provides the seed certification. The Association of Official Seed Analysts does not do certifications. They just create the rules. So they create the rules and standards for certification, and then the Department of Ag provides the seed certification. And that's how they work together. All seed distributors in Pennsylvania have to obtain an annual license from the Pennsylvania Department of Agriculture, and they have to get this license before January 1st and prior to distribution. This license costs $25 per year, and I don't think that's changed in a while. And I'm pretty sure that's still the cost, which is pretty reasonable. And the main thing to note under the Pennsylvania Seed Act is that selling seeds without a label or tag is illegal. The label has to be legible in English and in a conspicuous place on the outside of the container. So what needs to be included in the label for all seeds? So we have to have the name and address of the distributor, a treatment statement, how what's been applied to the seeds, any chemicals, things like that. And of course, the label can't be false or misleading. That's standard language we see everywhere, especially if you've read anything from FDA. And then you also have to include records and file sample of tested seeds. And you have to keep all your records for at least 2 years. One of the exceptions to this is the sale of a small amount of seeds from the large container to the end user is allowed. So as long as the original container has all the required information, for example, if you've got like a big container, it's got all the proper label information on it, and someone comes in and they just want like, I don't know, a small bucket worth of seeds, you can sell it to them without, putting a label on that small bag for the end user, and that's okay. So when it comes to agricultural seeds, the requirements are pretty similar. You have to include the accepted name of kind and variety. You have to have, if there's a mixture of seeds, if you're selling it as a mix, you have to have the word mixture, mix, or blend on the label. And anything that has, components of 5% or more, that has to be listed in order of magnitude. So if you've got 40% of this seed, that one goes first, 30% of this seed, that one goes second, 10% of this seed, that one goes next, right? And the seedless percentage has to be 100%. So you can't have like 95%. We know what these seeds are, and this 5%, who can say? Like, we're just gonna guess. No guessing. We have to have the full percentage of everything that's in there. So this is very strict. So it's very difficult, I think, to imagine to try to do this on your own. You really need to have your seeds tested by a company that's familiar with this process. And the weed seed limit is 1%. So, I mean, they're not going to want any kind of weed seeds in there, but you can have 1% at the very most. And apparently that needs to be labeled as well. So under the Pennsylvania Seed Act, labels for agricultural seeds must also include the lot number, and they have to include a label with the origin of all certified seeds. And so there's any certified seeds, they have to show like where they originated, and then also these other seeds that are listed very specifically. I thought was very interesting on the website. So all certified seeds, and also, red and white clover, field corn, except hybrids, things like that. It's a very picky list. And again, we have links to this. So if this is something that you're involved with personally, definitely check out the website. Lastly, agricultural seed labels have to include the name and the number of restricted noxious weed seeds. Now, noxious weeds, those can be pretty dangerous in an environmental sense by clogging waterways, filtration systems, and taking over ecosystems. They can also be harmful to human health by irritating or poisoning people who touch them. And you can find a list of noxious weeds on the PA Department of Agriculture website, and it includes weeds like Jimson weed, shatter cane, Canadian thistle, giant hogweed, things like that. And the label should include the germination percentage, hard seed, date at the germination test. So on the previous slides, we looked at the requirements for all seeds and the requirements for agricultural seeds. We are not going to go through the other label requirements because, first of all, they're fairly similar to the requirements for ag seeds anyway, and our focus is going to be agriculture. So, but these are the other type of seeds that have requirements under the Pennsylvania Seed Act. So tree and shrub seeds, vegetable and herb seeds, flower seeds, lawn, turf seeds, mixture, things like that. I just put this in. I mean, I feel like everyone should probably assume this, but you have to maintain your records. So if you're a seed distributor, you have to maintain records for each lot of seed that's handled, and you have to maintain those records for 2 years. And then you have to make those records available to the Department of Agriculture. So if you are a seed distributor, and you are distributing any types of seeds, you have to make sure that those records are available to the Department of Agriculture should they come knocking. So how are all of these laws enforced, or at least, the Pennsylvania Seed Act laws enforced? So the Department of Agriculture is authorized to enforce all chapters of the Pennsylvania Seed Act. They are authorized to stop by during regular business hours, to sample or inspect seeds that are transported. Anything that's transported, sold, or offered in Pennsylvania, they're allowed to inspect. And if the state finds a violation, they can issue and enforce a stop sale order. They can also suspend or revoke a distributor's license if they find any violations or of any portion of the Pennsylvania Seed Act. And then, of course, they can seize or condemn the seed itself, but they do have to give the individual an opportunity to apply for permission to process, relabel the seed, or otherwise bring the seed into compliance. I've mentioned brown bag seed a couple of times, and the Pennsylvania Seed Act specifically prohibits brown bag seeds, which is the industry term for unlabeled seeds. These are seeds that have not been properly tested or certified. And I've talked to too many farmers, and I have not talked to that many farmers, but too many of them think that this is fine, brown bag seed sales. They have no idea that this is very illegal, because it's like, well, this is just a small amount. This is my neighbor. We've been doing this for years. One of those handshake things, like I give him some of these seeds, he gives me some of these seeds. It's no problem. But brown bag seed sales are illegal because they've not been tested, certified, or properly labeled. This can be a bit of a problem. It's a risk to the ecosystem. It can potentially lower the germination rates of seeds. The seeds aren't purified, and it can be more difficult to control weeds. So on one hand, it can be easier to do it this way, but also problematic. So that's why they have these rules against brown bag seed sales. So if you are found to violate the Pennsylvania Seed Act, you could be liable for some civil penalties. This is a few years older, but I guess it's a couple grand for each violation. Criminal penalties. If the state decides to charge you with criminal penalties, you may pay anywhere from $50 to $100 for a first offense. But you could also get up to 90 days in jail for selling seeds, which the concept is wild to me. For the second offense, if you do something within 3 years, it's a little more serious. You're paying $500 to $1,000, and you could go to prison for a couple of years, which again, wild concept for violating the Pennsylvania Seed Act, that you could end up in prison. It seems like a lot. All right, things that are not covered by the Pennsylvania Seed Act, that includes libraries, seed libraries specifically. So these are usually nonprofit, community-based organizations. So local growers, they save seeds from season to season, and then they share the seeds with each other. They're not necessarily selling the seeds, they're just trading them. So as of 2016, there were about 26 seed libraries in Pennsylvania and over 350 seed libraries nationwide. Now, for a while, there was some confusion in Pennsylvania about whether seed libraries were subject to the Pennsylvania Seed Act. There was a bit of a movement focusing around the Simpson Library in Mechanicsburg, Pennsylvania. Now, the Department of Ag came out eventually and said that seed libraries don't qualify as seed distributors because they're not selling the seeds, and therefore seed libraries are exempt from the Seed Act. The Department of Agriculture now has a seed library protocol that you can find on their website. As you can see from the list on this slide, the library acts as a meeting place and a center for seed sharing. Seed libraries are a great resource for smaller farms, and it would be really difficult for these seed libraries to operate financially if they were obligated to test all the seeds that came through. And so the protocol, again, there's a link here on this side, there's a link in the resources page. But generally what happens is the library procures licensed and labeled seeds to give away. The members are allowed to check out the seeds from the library. They can grow the plants, and then they harvest the new seeds. And then the library acts as a meeting place for seed swap and trade. And then each year the library starts with fresh seeds. That's the protocol on the Department of Ag website. I'm sure that not all libraries operate exactly in that manner. And I know that a lot of seed libraries do rely on donations from people, but they can also purchase seeds to supplement where they have a need. I wanted to include this list here too. So as far as I was able to find, there's a handful of states with seed library exemptions, laws that they wrote specifically to exempt seed libraries from some of these more strict regulations. And it's especially interesting timeline, and that's why I included the dates here. So it was actually in 2014 that our Pennsylvania Department of Agriculture sent this letter to the Simpson Library in Mechanicsburg telling them that their seed library plans violated state law. Next thing we know, Nebraska and Minnesota passed their seed library laws in 2015. And then a year later, California and Illinois passed their seed library laws, 2016. And then, as we just covered in the last couple slides, PDA clarified that what they actually meant, not what they said in the letter, was that seed libraries were exempt from state seed law, the state seed law, so long as the seed library is operating as a nonprofit. And so that's how we ended up with the protocol that we have now with the Department of Ag in 2016. So here are some key takeaway points that I have for you today. So, and I do have a few more slides, but I wanted to kind of wrap up what we were talking about with these other laws before I get into some of the fun extra stuff that I have. So first, just a quick review. Patents. Generally, we're talking about utility patents or plant patents. Those are going to prevent the sale or planting of harvested seeds, or asexually or sexually reproducing seeds or tubers. I kind of bundled those all together with that point. And then the Federal Seed Act, that regulates the interstate sale of seeds. Anything sold between states needs to be certified. And then we have the PVPA, or the Plant Variety Protection Act certificates. And that says that, seeds can't be saved. They can't be saved and sold unless a farmer is saving those seeds for themselves and something happens, and then they can sell the seeds that they saved for themselves. No more than that. And then the PSA, that says that all seeds sold have to be labeled. So Pennsylvania Seed Act, everything has to be labeled in this state. So just a big cover there. And then, I don't know, if you are a farmer, this is some general good idea, things to think about. If you are an attorney advising a farmer, generally stick to this. First, don't save seeds unless you know that you're permitted to do so. Check to see with your seed distributor and read the label of the seeds that you buy. If it says that the seeds are protected, you might not be able to save and replant them. Find out what kind of protection it is. If it's a PVPA and you want to save the seeds for your own property, great. If it's any kind of patent, you're not going to be able to save them. Second, make sure that you are only purchasing properly labeled seeds from a licensed distributor. Your neighbor next door might offer you, a really good price for, some brown bag seeds. And it might be tempting, but if you buy them, you are taking a legal risk. Lastly, do not sell seeds unless you are a licensed distributor. You don't want to be that neighbor who's selling brown bag seeds to your friends and getting yourself and everyone else in trouble. You want to get licensed, get your seeds certified, and got to comply with all the red tape. It's a lot less of a pain to deal with the red tape than it is to deal with a bunch of lawyers down the road. Okay, I'm going to take a little bit of a pause here and see if we have any questions before I get into my fun extras.
We do have a couple of questions. Okay. So first of all, someone says, I don't know why one would want to, but why can't the PVP variety be used as a cover crop?
That's a great question. I thought that was really weird too. I mean, you can look at the link yourself. They don't explain why. They just say that you can't. And I'm wondering if it means that it can't be sold. I think what it actually means is not saying that you can't. Let me explain that further. So under the PVPA, you are allowed to save seeds for yourself. So if you were saving them for yourself to put it as your own cover crop, you can. But some people were trying to use that cover crop as an exemption for selling the seeds. So they thought, I can save some seeds and sell them to other people as a cover crop because it's not a real crop, so I'm not really selling it. So that, I should have made that slide a little bit more clear. I think that I'm assuming that that's what you meant by that question, because you can save them for yourself as a cover crop, as long as it's for your own fields, for your own purposes, but you can't sell them to other people for cover crop, even though they're not, really using that crop. It's still a sale yeah. Does that make sense?
That made sense to me. I hope that it made sense to Mr. Zook here. So great. Okay, and then we've got another question here in the chat. It says, do you know if PDA has any agreements with neighboring departments of agriculture agreeing on jurisdiction over seed lots that leave the state? Example, seeds produced in the state but conditioned out of state. No need to raise the question if you don't know.
So can you repeat that one more time? So sorry, that was a long question.
Do you know if PDA, Pennsylvania Department of Agriculture, has any agreements with neighboring departments of agriculture agreeing on jurisdiction over seed lots that leave the state. So seeds that are produced in Pennsylvania, but then are conditioned out of state.
Oh, I see. I see. So they're okay. Yeah, they're being taken care of. There's two different places that are treating them essentially. I understand that question now. Um, I imagine there has to be some sort of communication and agreement that goes in between the states because it's a federal law that requires them to regulate that. So I don't know what those would be. I wouldn't be able to pull that out of the top of my head, but I there has to be something like that. So I would answer probably yes. I'd be very interested in looking into that. But yeah, send me an email and I can look into that more because I think that's a good question.
All right, cool. And moving on, oh yay, we've got a cannabis question. Okay, so as Pennsylvania inches towards legal cannabis, do you have any thoughts how the gray area of state versus federal seed law might play out?
Oh my gosh, that is such a big question. Why would you throw that at me right here? I couldn't. I mean, I'm not a psychic. I'm not going to be able to tell you what's going to happen in the future. It seems like unless they really want to fight on their hands, we're going to have to, it would need to be legalized federally to just sort of smooth everything over. I think it's going to be really complicated if states try to do that. And I know that when I was doing my research for this, I did see that there have been some requests for patents of for federal patents for marijuana. And I believe that those have been rejected for the most part. Some of the names for them were spectacular. So it's if you're looking for a good time, I definitely look into that. But yeah, I think it's gonna be a long time coming. So like based on the information that I saw, it seems that the federal government is resistant to the idea of working on marijuana right now as the law currently stands. So yeah, I can't tell you what it's going to happen in the future, but I think that's a ways away.
Great. All right. Well, I know, Jackie, you've got a couple more slides for us, so I will pop back off here and let you finish up. Thank you so much.
Okay. And if you have any more questions, feel free to throw them in because I think I'm going to end a couple minutes early, so I might be able to answer one or two more.
And I will remind one more time, new CLE form, please see the chat, new CLE form.
Okay, so one thing I wanted to share with everyone, as I was pulling together some resources for this presentation, I stumbled across this chart on the USDA website. I just thought it was really interesting, and I thought some of the people here might find it interesting. So as you can see, it shows the number of patents and certificates issued for new crop varieties from 1971 to 2020. Now, the PVPA certificates are shown in the bluish purple color. The plant patents are in that yellowish gold color, and then utility patents are the grayish blue color. Overall, if you're looking at the chart, it looks like the patents and certificates have all increased over the past 3 decades. But as you can see, the issuance of utility patents doesn't start until like the 1990s. And then that skyrockets to become parallel with plant patents in these past recent years. It's also interesting that while PVPA certificates have been increasing pretty steadily, they did drop off a little bit in that last column. So it looks like utility patents have become a lot more popular, probably because they are so much more flexible and cover a little bit more, and they're a little bit more, I would say, stronger, because people can't save those seeds at all. And this could also be a sign of, genetically engineered plants becoming more of a big thing. And, companies don't want people to save those seeds, even if it's just for their own farm or their own purposes. So just a really interesting chart, and I have the link for that here. Just wanted to share that. I thought that was really interesting. Now, some things in the news, some things that are starting, but I don't really have a lot to say about it, but stuff that's just, to keep in mind for the future. So in 2021, we have this executive order that's titled Promoting Competition in the American Economy. And then this year, in March 2023, USDA Agricultural Marketing Service, they prepared this document, More and Better Choices for Farmers, Promoting Fair Competition and Innovation in Seeds and Other Agricultural Inputs. So what happened here is we've got this executive order, and in response, the Ag Marketing Service prepared a report with 3 goals. They wanted to ensure robust and reliable intellectual property rights, ensure that intellectual property owners exercise their rights within the scope of competition, and rebuild critical infrastructure for seed development and strong seed supply chains. So this whole thing is all about like, making sure that companies are playing fairly, right? But at the same time that we're supporting new seed development. So what does this look like? We've got some action items in the report. The USDA says that they are going to create a farmer seed liaison, and this person in this position is going to do public outreach to farmers and plant breeders and act as a liaison to the U.S. Patent and Trademark Office. And they are also going to, they being USDA, they're going to create a working group within the U.S. Patent and Trademark Office, which is going to focus on stakeholder input, transparency, and fair competition. We don't have a great idea of what either of these action items are going to look like. Right now, there's no published timeline that I could find of when we can expect to see more, but depending on what happens, it may be a topic for a future webinar. The last point on this slide is that the notice to trade that was issued by MS. This isn't anything new. This is just a reminder to the seed industry to disclose the kind and variety of seeds being sold. They're already required to do that under the Federal Seed Act. So I thought it was really interesting that in this report, they made a highlight, like, we reminded these companies that they have to disclose the kind and variety of seeds that they're selling. Like, thank you for doing that. Like, I don't know, I thought it just seems a little silly because it's, they should know that they have to do that. But that's something else that they reported. So this is a very big, very lengthy report. If you need something to put yourself to sleep at night, this is a great read for that. But it really doesn't say anything yet. I imagine that we're going to get a lot out of this soon, though. So this is just something to keep an eye on for later. And then the other last thing that I wanted to touch on before I bring it back to any more questions that we might have is treated seeds. I didn't really cover this because this is really more of a pesticide issue than a seed issue, but it's very related. So I did want to mention them briefly to not neglect the issue. Treated seeds are seeds that have been coated with pesticides. And the benefit of this is that the seeds, when they're planted, they already have these pesticide properties, so they're protected from pests and things like that. It's very efficient. The issue that people have is that typically pesticides are regulated by the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA. FIFRA, though, it has a treated article exemption, and it says that treated seeds are exempt from their pesticide registration requirements, which is really interesting. And now you might suspect just from that statement, of course, a bunch of environmental groups have taken issue with this. And then earlier this year, May 2023, the Center for Food Safety filed a complaint arguing that the exemption violates FIFRA and the Administrative Procedure Act. The National Ag Law Center, I keep throwing things out to them. They've got a great article on this topic. They did a really nice job on it. So the link to the complaint is here on the slide. The link to the NALC article is on the slide and in the resources. But this is a really interesting topic, maybe something that we talk about more later once we find out what happens here. I could see this case going either way, whether the FIFRA decides that this is something that's going to be covered, or, whether it's rejected by the court. So at that, I think I'm just about done.
All right. Well, I think that's all we have for you today. I don't see any more questions in the chat. Yes, and I see people are filling out the polls. Great. All right. Well, we will end just a few minutes early this afternoon and let you get back to your work, and hope that you have a great weekend. We've got 3 more programs coming up here before the end of the year: Fair Labor Standards Act, Perishable Ag Commodities Act, and food labeling. Yes, and please get CLE forms in. If you have any issues with CLE, email me aet17@psu.edu. And with that, thank you so much for attending, understanding the basics of federal and state seed laws, and we wish you have a happy weekend. Bye all.